everyone. Today's case is with respect to the Sajjan Singh versus the state of Rajasthan. We all are aware with the case of Shankari Prasad, and this case is in line with that case. Let us see what different issue was involved in this case. So the name of this case is Sajjan Singh versus State of Rajasthan. It was decided by the Supreme Court of India on 30th October 1964, and the citation of this case is 1965 Supreme Court. It was decided by 5-judge bench comprising following justices, in which 2 of the justices had hold the dissenting opinion on some issue. So let us see what was the bench and in which 2 of them have hold the dissenting opinion. So it was the P.V. 𝐤𝐴𝐺𝐵 justice, along with him 𝐸𝐴𝐚 justice, M. Hidayatullah justice was there, and Raghupar Dayal justice, and along with him J.R. Madholkar justice was there. And out of these judges, Justice M. Hidayatullah and Justice J.R. Madholkar have hold the dissenting opinion with respect to one of the issue. I'll let you know what dissenting opinion they have hold in this case. So let us see what was the fact of this case. This fact revolves around the 17th Constitutional Amendment of 1964. We all are aware with the very first Constitutional Amendment Act, whose validity was challenged in Shankari Prasad case. Through first Constitutional Amendment Act, Article 31A and Article 31B was inserted in the Constitution of India to bring the land reforms, and moreover 9th schedule was inserted in the Constitution, because if something is kept in 9th schedule, that is immune from judicial review. So what happened? Through this 17th Constitutional Amendment Act of 1964, the word state, which has been given under Article 31A and 31B, has been given a wider meaning, and state legislation has been put under the 9th schedule, whose validity was challenged by the petitioner Sajjan Singh in this case. So what happened that there was the state of Rajasthan, and the Rajasthan legislature have enacted various land reform act. So land reform act was enacted in the state of Rajasthan, and these land reform act were enacted in order to bring agrarian reform in the society, to bring social and economic justice in the society. And when this act was enacted, it empowered the government to get the land of the people, to acquire the land of the people, and to distribute to the landless person. It means from the jamindar, the government has the authority to acquire the land and distribute it to the weaker section of the society. And what happened? That through 17th Constitutional Amendment Act, this Rajasthan Land Reform Act was put in the 9th schedule, and specifically entries 21 to entries 64 of the Rajasthan Land Reform Act was put in the 9th schedule, so as it is beyond judicial scrutiny. So the petitioner allegation was that through this 17th Constitutional Amendment, his fundamental rights are infringed regarding Article 19, Clause 1, Subclause G, which empowers the citizen of India to practice any profession, to carry on any trade, occupation or business. So he said that if land will be acquired through the government, because it gives massive power to the state to acquire land. So he says that his right to carry on any profession, trade will be infringed, and moreover, he has challenged Article 368 of the Constitution also, which gives the amending power to the Parliament. Petitioner allegation was that whether Parliament has the right to amend the fundamental right, because fundamental right are inherent right which a human being have. So whether Parliament can even infringe the fundamental right through enacting any law. This was one of the issue, and moreover, he has contended through his petition before the Supreme Court that even the Article 226 is being violated. It means High Court ki power is also being violated, because by keeping the laws in 9th schedule, it is beyond the judicial scrutiny. So the validity of 17th Constitutional Amendment Act of 1964 was challenged, which has put the Rajasthan Land Reform Act in the 9th schedule. Through that amendment, the word estate has been given a wider meaning. In other words, it empowers the state of Rajasthan to acquire land of the people and distribute to the landless person. So, he had challenged the validity of 17th Constitutional Amendment. Moreover, he has claimed that through that action of the Parliament, his fundamental right, that is which is given under Article 19, Clause 1, Subclause B, 9, Article 19, Clause 1, Subclause G, which talks about right to practice any kind of profession, to carry any trade, business, occupation, that is being infringed. And moreover, he claimed that Article 368 gives the massive power to the Parliament to amend the part of the Constitution. So whether the Constitution ka part 3rd can be amended by the Parliament, and is it not the infringing High Court's ka power? Because if something is kept in 9th schedule, that is beyond judicial scrutiny. So these are the key issues which was involved in this case. Because something is kept in 9th schedule, it means that is beyond judicial scrutiny, and his contention was that Parliament have exceeded his competency. It means he had exceeded his legislative competency by enacting those laws. It means whether that was permissible within the constitutional amendment to amend even part 3rd, that was the key issue in this case. Now let us see what provisions are involved. It is Article 19, Clause 1, Subclause G, because he claimed that if the Jamindar land will be acquired by the government, how they will be carrying on their trade, occupation, business with respect to the land. So he claimed the infringement of Article 19, Clause 1, Subclause G, which gives the right to practice any profession, and it also empowers the citizen of India to carry on any trade, occupation or business. So he claimed that his Article 19, Clause 1, Subclause G is being infringed. Moreover, he claimed that by Article 368 of the Constitution, whether the Parliament can amend part 3rd of the Constitution. It means whether the Parliament can amend fundamental right also. Is it not violating the High Court's power under Article 226? And moreover, Constitutional 17th Amendment of 1964 was challenged, because through this 17th Amendment only, Rajasthan Land Reforms Act was put in the 9th schedule, and it was beyond the judicial scrutiny through this amendment only. We all know that Article 19, Clause 1, Subclause G guarantees to every citizen of India to practice any profession or to carry any occupation, trade or business. And moreover, Article 368 empowers the Parliament to amend any part of the Constitution. And amendment ka there is a procedure. It could be done by simple majority or by special majority or by special majority plus the ratification of 2/3 of the state. Even the Sajjan Singh have claimed that ratification was not asked from the state, because land is a matter of state list, and you have not asked when you are amending the law, you are exercising your power of amendment, and ratification is needed if something is there in the state list. So what about that? Ratification, he contended that also. And Article 31A and 31B में the word state has been given a wider meaning through this 17th amendment only. And these are the key provisions which was involved in this case. Now let us see what the Supreme Court has decided with respect to the issues. The Supreme Court has held that 17th constitutional amendment is perfectly valid and it is constitutional because it does not infringe the fundamental right of a person, because this particular amendment was made to bring the agrarian reform in the society, to bring the land and the social reform. Such thing has been done. Something is put in 9th schedule so that land which has been acquired by the government can be distributed equally among the people. That was being upheld by the Supreme Court. Moreover, court has held that the power of the parliament under Article 368 is void enough to amend any part of the constitution, be it the part 3rd, because the word law under Article 13 does not include the thing which has been done through the amendment. It means what law has been made through amendment, that is not being covered under Article 13. That again Supreme Court has made clear through this judgment. Moreover, as Justice M. Hidayatullah and Justice Madhulkar have dissented on this point, they said that as the fundamental rights are the basic rights which are given to a human being and that are not amenable by the amendment power of the parliament, and moreover this contention has led a basis for the doctrine of basic structure which was laid down in the case of 𝐬𝐴𝐴𝐻 Bharti, because we can amend anything provided the basic structure of the constitution is intact. So the basis of dissenting opinion has led the foundation to the case of 𝐬𝐴𝐴𝐻 Bharti, and moreover this judgment was later on overruled by 𝐬𝐞𝐝𝐢𝐚 case, which we will be letting you know through this series only. So the Supreme Court held that 17th constitutional amendment is all valid because it was made to bring the agrarian reform in the society. It is not violating Article 19 clause 1 subclause G. It means it is not violating fundamental right of the person. Moreover, it has said that through this amendment High Court's power is also not being violated, because if something is kept in 9th schedule, it does not mean that it is violating the power of the judiciary. So High Court's power is not being infringed through this amendment that was laid, and moreover the court have High Court power which is being given under Article 226, that is in line with the other provisions, and judicial scrutiny does not say that they can review anything. There must be a balanced approach between the parliament's power of amendment and the judicial scrutiny on the other side, and court has made it very clear that in order to bring the change in the society, to implement the socio-economic policies, such kind of amendment is being done by the parliament and such kind of immunity is being there, and that's why they have been put under the 9th schedule. Now there is a practice question for you. Even though this judgment was not right when it comes to with respect to deciding something on the fundamental right, and that change in the approach we will be seeing, because this case was overruled in the case of 𝐬𝐴𝐴𝐻, and dissenting opinion has laid the foundation for the 𝐬𝐴𝐴𝐻 Bharti case. So this judgment is important in that context because it has laid the foundation on which the doctrine of basic structure was laid down. So now there is a practice question for you. You have to tell what was the primary legal issue which was involved in the case of Sajjan Singh versus State of Rajasthan. Is it option number A के according the validity of 17th constitutional amendment, or it is the option number B, definition of the fundamental rights regarding the issues there, or is it with respect to the jurisdiction of the High Court, or the option D says is it with respect to the scope of state legislative powers. In subjective question, you have to discuss the implication of the Supreme Court's ruling in the Sajjan case, that is Sajjan Singh versus State of Rajasthan, that how the balance is drawn between the legislative power on one hand and the fundamental right on the other, and how this case has influenced further constitutional amendments which deals with the socio-economic policies. So this you have to write in the subjective answer. Thank you.